So friends, as we all know, we have completed the parliament. Yes, we have completed the friends parliament, and out of the four organs, out of the four main organs attached with the union government, that is executive, legislature, judiciary, and CAG, Comptroller and Auditor General, that is Accountant of India. We have completed legislative and executive. And now from today, we are going to start, friends, judiciary. But first of all, you all must know what is the meaning of judiciary. So friends, let me tell you, I have already told you previously. Sir, you should be thinking, sir, where you have told us? So friends, in the starting, in the first lecture only, I had explained you what do you mean by legislature, what do you mean by executive, and what do you mean by judiciary. So I told you there that Judiciary is like a parent who's tried to solve the disputes of its children or the disputes between father and children. I mean to say, judiciary is a body which solves the dispute between the citizens of the country or between the union and the citizens of the country. And in a country like India, a powerful judiciary is very much needed. Ab, how can I say that this is true? So try to understand, friends. If we talk about India, so India Constitution is supreme, but still, if anyone if anyone that is Parliament tries to misuse his powers, try to mug it out a wrong meaning from the Constitution, then in that case, who will who will save the citizens of the country? So in that case, friends, the Supreme Court will save the citizen of the country, because it is what? It is interpreter of the Constitution. It is what? It is the interpreter of the Constitution. Many a times it has saved also. For example, when Indira Gandhi was changing the things in the Constitution at a very rapid pace, it generated a new term, friends, that is the basic features of the Constitution, with the help of which the Supreme Court made it mandatory for the government to not change the features that are part of basic features of the Constitution. I guess it is clear to you now. Now, other than that, as we all know, our country is federal in nature. But in a federal country, there is a division of power, and that is the division of power between center and state. So it can happen that center, that is Narendra sir, tries to misuse his power. So in that case also, it is judiciary who makes a balance. If you remember, in the Uttarakhand government, that is of Harish Rawat's government, a case was filed in the court in which the Harish Rawat was telling that the president rule was imposed not in the correct way, it was a misuse of constitution. So at that point of time, the judiciary also realized that Narendra Modi's government is misusing his power. So it declared that president rule to be non-constitutional. So center state relation. Other than that, friends, as we all know, in our country, we practice the parliamentary form of government. So the parliament has the power to amend the constitution. So it is not just क्या कहते हैं, judiciary. It is not just judiciary's duty, but also it's judiciary's power to protect us in these type of circumstances. That's why it is called what? It is called custodian of the constitution. What I said, friends, it is called custodian of the constitution. Other than that, other than that, if we talk about India, friends, we all know India is a poor country. By poor I mean a huge number of people in India are poor. So poor people are always exploited by the rich people in the country. So in India, it was urgent needed that the rights of these poor or exploited people should be saved. That's why the judiciary's role is important here also, because it is what? It is the protector of fundamental rights. You must be remembering Article 32, in which I taught you habeas corpus, mandamus, is other than that prohibitions, certiorari, quo warranto. So it is also protector of fundamental rights. So in order to establish democracy, we all say democracy is of the people, for the people, by the people. But to ensure that the democracy is real in reality established, we have adopted separation of powers. Separation of powers between three organs of government: legislative, executive, judiciary. Legislative, executive, and judiciary. And among them, the role of judiciary is, friends, very important, and that's why we had adopted what? We have adopted a independent and integrated judiciary. What do you mean by independent and integrated judiciary? I have explained you a piece of it while explaining the characteristics of Indian Constitution. There I explained what do you mean by independent and integrated judiciary. But try to understand in a simple way once again that in our country, we all know we have district court in all the districts. Lower than them are municipal court and gram nyale. Okay, so if we talk about district court, if a high court, if high court disagrees with the decision of district court, then as we all know, high court can change the district court decision. But on the same hand, if Supreme Court does not agree with the high court decision, then the Supreme Court decision will be of more value than High Court, and it will be mandatory for all the lower courts to follow it. That's why, since because it is why we can say in India we have integrated judiciary, that is all the judiciaries are connected, and Supreme Court is what? Supreme Court is the apex judicial body in our country. Apex means, friends, topmost. It is the topmost judicial body in the country. I guess it is very much clear to you now. Sir, what do you mean by independent? So friends, try to understand. Independent means it will work on its own discretion. I don't remember in which lecture I explained you, but I explained you that with the help of National Judicial Appointment Commission, that is 99th Constitutional Amendment Act, Modi ji tries to increase his share of vote in the while selecting or electing a Supreme Court judge. But the judiciary said that an independent and integrated judiciary is part of our constitution, basic feature of constitution. So you cannot change with the help of National Judicial Appointment Commission. So that's why it declared National Judicial Appointment Commission to be null and void, and that's why the constitutional article, that is 99th article, was not practiced or is not practiced or followed today also. Now continuing it, there are some key facts. There are some key facts related to this which you all should know, friends. For example, you all must know when was judiciary established. You must be thinking, sir, these date-like questions are asked in polity. So friends, there are some date-wise questions which are asked in polity too. Usually date-wise questions are asked in history, but there are some questions which are asked in polity too. For example, establishment of Supreme Court. So it is very easy to understand, friends, nothing to worry. We all know our constitution was क्या कहते हैं, implemented on 26 January 1950. So after the implementation of constitution, 2 days after the implementation of constitution, our Supreme Court got established. In this way you can learn it very easily. Now continuing it, you must know what is the present and initial number of judges. So friends, try to understand, in Supreme Court we have two types of judges, that is a Supreme Court judge and the other is CJI, that is Chief Justice of India. Sir, why so? One Chief Justice of India is good enough for Supreme Court? So try to understand, friends, this Supreme Court, it has to fought the cases of whole India. Alone CJI cannot have held such huge number of cases. He needs some assistance now. That's why when our India got independent, since our population was near about 40 crores, we thought 8 judges would be sufficient to deal with the cases of 40 crore population. But as we all know, friends, presently our population is 120 crore, 22 crore, and this is such a huge number that that a few number of people, that is 8 number of judges, it not sufficient to deal with it. That's why if we talk about the present strength of judges, it is 33 plus 1. So if I talk about you the number of judges in totality, so it is 34. But if I talk about the number of judges excluding the Chief Justice of India, so friends, it is 33. Now you all must know where the bench of Supreme Court sit, where the sitting of Supreme Court happens. Yeah, I must say where this beautiful Supreme Court, which is given in front of you, is present. So friends, as you all know, it is in New Delhi. These are the facts which are very much important and asked in exam. Other than that, you all know while dealing with president, vice president, parliament, etc. What we have been studying? We have been studying. You all know it very well. We have been studying qualifications, appointment, oath, tenure, removal. So in the same way, in this Supreme Court also, we would be dealing with the same number of things, friends. So first of all, we will deal with appointment of judges. But you must be thinking, sir, you have not mentioned the articles here. As we have seen your teaching style, you always mention the articles. But here, as we see, you are not mentioning the articles. So, friends, try to understand the articles are not very much important while dealing with Supreme Court, because the most important things are mentioned in the starting article, that is Article 124. But still, let me mention you some articles. For example, appointment of CGI. If I talk about appointment of judges, so friends, appointment of judges has been given in Article 124 only. But there are huge layers. That's why I'm not mentioning the article. So first of all, try to understand who will be. That is a question to be asked in exam. Who appoints the Supreme Court's judges? So friends, the Supreme Court judges are appointed by President. Now you must be thinking, sir, you abhi told na that the Supreme Court judges are elected independently. They are not to deal with the Parliament. So how come the Supreme Court judges are appointed by President? So try to understand, he is just appointing, but the selection or recommendation is given by the Collegium of Judges. Sir, what is this Collegium? Collegium is CGI plus 4 senior most judges of Supreme Court. When I was student, I was very confused, friends, that the does 4 senior most judges include CGI? So friends, they do not include CGI. You can see CGI Ranjan Gogoi and the 4 senior most judges. Now you must be thinking, Sir Sharad Arvind Bobde is present Chief Justice of India. So why have you have mentioned Ranjan Gogoi's photo? So I have mentioned Ranjan Gogoi's photo in order to make you understand better, friends, that Sharad Arvind Bobde was second most senior judge when Ranjan Gogoi was CGI. And in Supreme Court, it is a practice, it is a back practice by tradition that the senior most judge is directly made CGI. So after Ranjan Gogoi, as we all know, has gone to Rajya Sabha. Many accusations were pointed on him for this. So after Ranjan Gogoi, as we all know, Sharad Arvind Bobde has become the Chief Justice of India. See, President Ramnath Kovind delivering oath to Sharad Arvind Bobde ji. Now, after Sharad Arvind Bobde, if everything goes well, N.V. Ramana will be the next Chief Justice of India, next CGI of India. So, continuing it, there are many. I must tell you there are many more layers which are to be explained to you by me, but at present I am not explaining because I think you all will get a lot of confusion and a lot of problem while understanding these things. So that's why I am continuing it. Now continuing it, the next article is oath of a judge. Oath of a judge, this all is present in friend article 124 only. That's why articles are less important, and the description, the explanation which I am giving to you is more important, because people are not able to digest that the Supreme Court judge has been appointed and given oath by president. So it is very frequently asked in the exams. Oath of a judge. Friends, as we all know, most of the influential posts of India, most of the influential and constitutional posts of a country are being given oath by president only. So in the same way, Sharad Arvind Bobde is also given by president only. But sometimes if it happens that president is not available and he is busy, then in that case he has to appoint a person to give oath to the president. And you all know it very well that it has been done through article 99 also for the parliament members, because there also the oath delivery work was of president only, but it was done by a pro tem speaker. Now continuing it, the next is tenure or vacancy. So you must be thinking, it is a question asked very frequently in exam, friends. If I talk about the president tenure, 5 years, vice president tenure, 5 years, Lok Sabha tenure, 5 years, Rajya Sabha tenure, 6 years. You will be studying after Supreme Court and High Court, CAG tenure, Comptroller and Auditor General, 6 years. So everybody is pretty much sure that Supreme Court's judge tenure will be also 5 years or 6 years. So let me tell you, friends, it is not the case. The Supreme Court judge's tenure is not 5 years or 6 years. It is 65 years. Now you must be thinking, sir, 65 year, will he be leading Supreme Court for 65 years? So no, friends, that is not the case. It means that if a Supreme Court judge, try to understand, if I talk about these senior most judges, have a look on them. Have a look on them. You will see for themselves. They all are near about more than 50 to 60 year age. So when a Supreme Court judge, try to understand, you will get confused. When a Supreme Court judges are 34, huh? When a Supreme Court judge becomes CGI, normally he is 62, 63, 64 years of age. So that's why it is a provision that, or it is a provision constitutionally, that he will lead the Supreme Court as a CGI until he becomes of age 65 years. Other than that, other than that, he can also become a Supreme Court judge till the age of 65 years only. For example, KM Joseph, if you have studied Harish Rawat case, then you must be knowing KM Joseph. He is a junior judge of Supreme Court now, and he is more than 60 years of age. And it has been calculated that it is very tough. It is very tough that he becomes CGI before attaining 65 years of age. So for the tenure of a Supreme Court judge is 65 years. If 65 years of age, if before attaining 65 years of age, your senior members senior to you becomes retired, then no problem, you will be appointed CGI. But if that does not happen, then in that case, friend, you will not be appointed CGI, and the person, and you will retire being a Supreme Court judge only. Now the thing is, he gave his resignation to whom? Obviously, friends, he will give his resignation also to the president. President is the Raja, na? So the resignation, appointment, oath, all to be done by president. Other than that, there are other circumstances like parliament members when he can empty his post. Like for example, accidental death, Obviously, death can never come telling us. Death मौत बुलाकर नहीं आती है, बोलकर नहीं आती है. Death never comes telling us that he is coming. So after death he cannot become a Supreme Court judge. What a joke, huh? So next thing, he is removed from the post by the president as in the procedure prescribed. Try to understand, friends. If I talk about Supreme Court judge, it is a post of prime most importance. And if a person of this post is misusing his power, then there should be a way. There should be a way in which he can be removed, because the work of Supreme Court is to establish judiciary. And if they are not doing their work properly, then the check and balance system in our country will get ruined up. So there are some definite grounds on the basis of which a Supreme Court judge can be removed. That should be remembered by you, because it can be asked in exam. That is proved misbehavior or incapacity. साबित कदाचार एवं असमर्थता. In easy way, we can say he is doing corruption, or he is not. He is not fulfilling his duties. For example, incapacity, asamarthata. For example, as a Supreme Court judge, you have to maintain law and order, and if you are not doing that, you are continuously favoring the government or making corruption things. So in that case, you can be removed from your post. Now, if we talk about, friends, removal motion, so there is a definite procedure by the help of which you can be removed. So friends, I guess you all must have seen the Deepak Mishra news. Deepak Mishra, Deepak Mishra was a Chief Justice of India on whom allegations were made that he is continuously favoring the government. That's why in Rajya Sabha, Ghulam Nabi Azad with his 50 members, that's why in Rajya Sabha, Ghulam Nabi Azad, that is the leader of opposition in Rajya Sabha, filed a motion that he must be removed from his post. Because as we can see, the provision says that if Rajya Sabha members are trying to remove the Supreme Court judge, or that is the CJI, so there should be 50 members to bringing this motion, and if it is to be passed from Lok Sabha, then there should be 100 members. So why so? Definitely, friends, the strength of Lok Sabha is more than Rajya Sabha, and since the strength of Lok Sabha is more than Rajya Sabha, the majority members required in Lok Sabha is also more than Rajya Sabha. I guess it is clear to you now. Now continue it. Try to understand, what if it get passed? Then in that case, if speaker accepted, then a 3-member committee is appointed. This 3-member committee, friends, does what? It investigate the charges. If I tell you about the previous cases, then B. Ramaswamy. See, it is B. Ramaswamy, Supreme Court judge. He is the only Supreme Court judge. I cannot say only now. Deepak Mishra has also become a judge on which this type of case, this type of hearing has been happened. So Supreme Court judge, if we talk about the Supreme Court judge, that is B. Ramaswamy. He was a judge, on him this committee was made, and this committee found him guilty of 11 of the 14 charges. The charges, if I tell you in short, the charges were that he is living an extravagant life as a Supreme Court judge. जरूरत से ज्यादा पैसा और जरूरत से ज्यादा खर्चा सुप्रीम कोर्ट जज के द्वारा इनके ऊपर हो रहा था. So corruption charges were put on him. So this committee found him guilty. Now must be thinking, sir, who all are the members of committee? So friends, CJI, Chief Justice of High Court, and a distinguished jurist. Distinguished jurist is what I previously told you, a person who knows a lot about the law and courts in the eye of president, is a distinguished jurist. So if they found guilty, then in that case the motion must be passed by both the houses by special majority. Remember friends, as I told you, there are three types of majority in the constitution, that is simple majority, effective majority, four types of simple majority, effective majority, absolute majority, special majority. Simple, effective, absolute, special. Simple majority, creation or abolition of state. Effective majority, Lok Sabha and Rajya Sabha chairman speaker के time I explained you, and its absolute majority, mm, for making a government, absolute majority required. And the last one is special majority. Special majorities have also a lot much layer on it. There are three to four types of special majority. The highest one is of president, that I have taught to you in Article 61. So we will explain it. I will explain it to you in your mains classes. What does this special majority exactly means? Okay. So this motion must be passed by both the houses by special majority. And after passing this motion, it must be sent to the president. And if the president signs on it, if the president signs on it and the judge is removed from the post, then if the president signs on it, then the judge stands removed from his post, friends. I guess it is very much clear to you now. Now if we talk about the articles, as you can see, I didn't explain you the articles because as I am telling you, most of the things are written in friends article 1 to 4 only. But there are some things on which the articles should be learned or remembered by you. That is the powers of the Supreme Court. Friends, if I talk about the powers of the Supreme Court, it is the most powerful court, not in India only. It is the most powerful court in the whole world. Supreme Court is the most powerful court, that is more powerful than American and British court. How come? Friends, as I explained you in characteristics of Indian Constitution, if we talk about the British court and American court, the British court is independent. The British court is a independent one. By independent, I mean, so sorry, I am saying the wrong thing. The British court is a integrated one. The British court is a integrated one, and the American court is a independent one. What means, sir? What you are trying to say? So, friends, I am trying to say that the American court, the American court has the power to scold the legislature and executive bodies too, because it is an independent one. British court does not have that power. In British, the parliament is the strongest, and the court cannot challenge the parliament. But still, there the parliament is there the courts are integrated, and America's court are not integrated. There are federal courts which are not which whose decisions are not to be strictly followed by the states. Haji. But if we talk about our Indian constitution, then our Indian constitution says our court is our Supreme Court is more Supreme Court is both independent and integrated. So it is the most powerful court in the whole world. So if I talk about its power, so friends, we will deal with this in detail in our mains classes. But let me explain you in short. First of all, friends, comes original jurisdiction. Original jurisdiction, by name only you can understand. First of all, you must know what is the meaning of jurisdiction. So jurisdiction means, friends, Karyakshetra. Karyakshetra, the area in which they are able to work. So friends, as we all know, our judiciary is of India. So definitely their jurisdiction will be what? Their jurisdiction will be whole India. So you must be saying, sir, what is important thing to know about this? So friend, try to understand. If I talk about High Court, then the jurisdiction of High Court is not whole India. It is its state only. So friend, try to understand original jurisdiction. By name it is clear the cases which are of original nature for Supreme Court. It means that the cases which can be dealt by only the Supreme Court, which will directly come to the Supreme Court. These type of cases come under original jurisdiction. So if I try to explain it to in detail, if there is a case between government and state, or if it is a case between two states, that is water disputes and all, so in that cases it can directly originate in the Supreme Court. It is of original jurisdiction, means you do not have to follow the hierarchy that first go to district court, then high court, then Supreme Court. This is called, friends, original jurisdiction. Other than that, the most important thing is appellate jurisdiction. Appellate jurisdiction, friends, as you all know, Salman Khan first fought a case in district court, then high court. Now he has moved to Supreme Court. So how it is happening? So friends, we have the procedure of appealing. We have the procedure of appealing through district court, high court, and then highest court, apex court, that is Supreme Court. In both the matters, that is civil matter and criminal matter. So Salman Khan's decision is a criminal one. So in civil and criminal, both types of matter, we all have the power that what should be done. If we are not satisfied with the decision of the district court, then we go to high court, and if we are not satisfied with the decision of high court, then we move to Supreme Court. But there are a lot much layers in it. If I explain it to detail, so try to understand, friend. After moving from a high court, if you want to move from a high court to Supreme Court, then you cannot do it very easily. It can only be done when the Supreme Court and the High Court certifies that it is a case fit to be fit to be fit to be moved to Supreme Court, or through Article 136. If the Supreme Court himself tells, if the Supreme Court himself tells that by leave I agree, by the leave given by you to me, I agree that this case should be taken by me. So in that case, the Supreme Court will get the case transferred from High Court to Supreme Court. But don't be afraid. This type of tough situation is not with the criminal cases. This type of tough situation has to be followed for the civil cases only. If we talk about the criminal cases, the procedure is somewhat different. For example, if a district court frees you from all the charges mentioned against you, but the high court cancels your acquittal, or high court cancels your acquittal, and it charges you of death, it charges you with the contempt of death. So in that case, you can easily get your case transferred to the Supreme Court, that is appellate jurisdiction. These two are the most important one. Other than that, friends, writ jurisdiction. I guess you all must be knowing Article 32, that is right to get fundamental rights protected, is himself a fundamental right. Right to get fundamental rights protected is itself a fundamental right. I guess you all know it very well. Now, friends, try to understand. You all must have heard contempt of court. If you are studying and you are seeing Prashant Bhushan case, so Prashant Bhushan case is a classic example to understand contempt of court in depth. Okay, so contempt of court, it means to say whatever Supreme Court has said, it is a testimony in itself. Whatever Supreme Court has said, it is a testimony in itself. ये अपने आप में एक सबूत है जिसको you cannot deny, and if you deny that, it is a contempt of court. कोर्ट के आदेश का अपमान है ये, और in that case you must be or you can be punished for it, and that is mentioned in Article 1 to 9. So very important, these articles you must remember, friends. Other than that, there are two more things, that is advisory jurisdiction and revisory jurisdiction. So friends, both are very much confused by the students, but both are very much different. So try to understand advisory jurisdiction. It means to say, if the president asks on the question of law from the Supreme Court judge, that is CGI, then the CGI has the power to give advice to the president. If you remember preamble, okay, I have not explained it to you because I explained it in my mains classes. So if you remember preamble, so while understanding that preamble is a part of constitution or not, this was a question asked by the president in the Berubari case 1960 to the Supreme Court judge. That is a presidential reference, that is called a presidential reference. So that is advisory jurisdiction, with the help of which a question of law should be answered by Supreme Court judge CGI on the if the president is asking that. But if we talk about revisory jurisdiction, that it is completely different, friends. So try to understand, friends, the Supreme Court. The Supreme Court is a apex judicial body. And if we talk about the society, with the passage of time, friends, society always what? It always changes. So if the society is changing, so try to understand the Supreme Court should also change its view. So that's why revisory jurisdiction is mentioned, is given through Article 137. I forgot to mention it in the 6 points. That's why I'm explaining it differently. So revisory jurisdiction is the power of the Supreme Court to revise its own decision. For example, preamble. Let us take an example of preamble. Initially, it was thought that preamble is not part of a constitution. But after some years, Supreme Court reversed its decision, and in Keshwanand Bharti case and other cases, it told us that preamble is a part of constitution, and only the and it can also be changed, but only the basic features, while maintaining the basic features of the constitution. Now the third one, this I have already explained, friends, that the Supreme Court's decision will be mandatory for all the small courts to follow. Other than that, there should be one more thing you must be knowing, that is judicial review. So judicial review, this power, Supreme Court is getting this power from the Article 13, or many articles can be named in connection to this article. I have explained you while explaining Article 13 that Supreme Court can review the decisions given by the legislature and executive if they are derogatory to the fundamental rights. So the judicial review and revisory jurisdiction, these are two more powers which I forgot to mention. So I thought it would be wise enough to mention that them too. So in this way, the Supreme Court is a most important organ of the government because it maintains the check and balance system required for the establishment of judiciary, friends. I guess it is all pretty much clear to you now, friends. So friends, that's all for now. If you have any doubts, you can mention it in the comment section. So bye bye for now.